a federal judge Wednesday declared a mistrial in the prosecution of Nevada cattleman Cliven Bundy, his two sons and a co-defendant, citing the government's willful failure to turn over multiple documents that could help the defense fight conspiracy and assault charges in the 2014 Bunkerville standoff. The court does regrettably believe a mistrial in this case is the most suitable and only remedy, U.S. District Judge Gloria M. Navarro declared, issuing her ruling from the bench before a packed courtroom. The judge listed 6 documents or pieces of evidence that prosecutors failed to turn over before trial, including reports on an FBI surveillance camera posted outside the Bundy Ranch and documents that identified U.S. Bureau of Land Management snipers outside the ranch. She also cited an FBI log with entries that noted snipers were inserted and on standby outside the Bundy home, at least 4 threat assessments that indicated the Bundys likely wouldn't use violence and that the Bureau of Land Management was antagonizing the family, and an internal affairs document on the lead BLM agent Dan Love that said there were no documented injuries to desert tortoises by cattle grazing on the federal land. The mistrial dealt a significant setback to federal prosecutors, yet they may be able to retry the defendants. Both sides were instructed to submit legal briefs by December 29 on whether the government should be allowed to pursue a new trial. The judge indicated she'd likely make a future ruling on whether the case should be a mistrial with prejudice, meaning no future trial would be held. The Bundys and their supporters called the ruling a partial victory. They had sought a full dismissal of the case. Defense lawyers are expected to challenge any effort to retry Cliven Bundy, Ammon Bundy, his older brother Ryan Bundy and Ryan Payne, arguing that it was the government's failure to share relevant evidence before trial that caused the mistrial and they shouldn't be allowed to try it again under the double jeopardy law. The development in the high-profile, long-anticipated case disturbed public land and environmental advocates, who worry that the identified government lapses may bolster the defendants and their loyalists in their rejection of federal authority and intensify their fervor against federal control of public lands. Any federal stumbling in this prosecution still doesn't relieve the fact the Bundys have been breaking the law by grazing their cattle unlawfully on public land, and their cows are still out there every day endangering protected species, said Taylor McKinnon, a public lands campaigner with the Center for Biological Diversity. We want that problem fixed. McKinnon and Kieran Suckling, the center's executive director, gathered on the steps of the Nevada courthouse to protest the Bundys. The two also were counter-protesters in 2016 at Malheur National Wildlife Refuge in southeastern Oregon, where Ammon and Ryan Bundy and Payne led an armed occupation. The two are concerned that if the Bundys aren't held accountable for their actions, it will give further credence to their militant participation in a broader move to seize public lands and hand them over to states. The judge's ruling marked at least the 3rd time the Bundy family has thwarted a federal agency action. On April 12, 2014, at the Toquip Wash near Bunkerville, federal rangers retreated from carrying out a court-ordered cattle impoundment when they were met by hundreds of militia and armed supporters of Cliven Bundy and his family. In October 2016, a jury acquitted Ammon and Ryan Bundy and 5 others of federal conspiracy charges in the takeover of the Malheur Refuge, and now,